Officer Jabro testified that he believed that he, as it's pled, was in a reasonable apprehension of immediate bodily harm from the defendant in this case.
On count one, I find the defendant not guilty.
And we have certainly proved beyond a reasonable doubt that is exactly what happened.
On count two,
So therefore, it is definitely proof beyond a reasonable doubt that there was obstruction on the defendant's part, as he refused to give any identifying information to the officer in the incident case.
When asked what a blading motion is, the witness got up and demonstrated simply moving the body in a certain direction. Not raising the arms, and not raising the legs, not trying to attack somebody. So the state has failed to prove assault as to that first theory.
I think that act, which I say was assault, was improper, led to the action asking for the ID. And I find the defendant not guilty in that charge.
Mr. It looks like you submitted this on behalf of Las Vegas Corruption Line. So what is Las Vegas Corruption Line?
Okay. All right, argument?
Your Honor, I'll reserve for rebuttal.
Okay.
Judge, so this is a bench trial, there's no reserving for rebuttal, and just for the record, I didn't know if the state was resting.
Well,
I have no
I'm sorry, yeah, you're, okay. Now, it's up to you now to put on any evidence, any witnesses.
Sure, so the defense does not have any witnesses to call at this time. The defense rests. And what we're asking, Judge, before we do any argument, if the court can take a recess and review the exhibits with the footage of the incident, and then we can resume with closing arguments.
Want me to review the exhibits again?
Just the video. I didn't know if Your Honor
No, I'm
wanted to look at it
satisfied.
again.
I'm satisfied with the video.
Okay.
I have no objection with that.
Okay.
The only question I had, the video that I didn't clear is the ID, which he claims that, I wasn't clear on that. Did you find the ID, or
No, Your Honor, my department did.
your partner did? Okay,
Yes.
okay, that's the only thing I,
Okay.
okay.
All right, so just renew again, Judge, because this is a bench trial, the state can't waive and reserve. They would have to go ahead and argue, and then we'll rebut. And I would ask that the witness step down from the witness stand.
Well, yes, if you're done now, question. Okay, you can step down, okay?
Yes, Your Honor.
I just want to make sure that I didn't have any other questions. So.
Sure, thank
That's
you,
all.
Judge.
Okay, now does the defense rest?
The defense does rest, Judge.
Okay. And we'll go over the state. You reserve the right to argue, have the defense argue.
Okay. Your Honor, yes, the state is prepared to give a closing argument, although for the record, there is no legal authority saying we can't just reserve for rebuttal. However, I'm more than happy to give a brief closing argument.
Wait a minute, she hasn't, okay, go ahead.
All right, Your Honor, so here, Mr. Corrales has been charged with assault, the misdemeanor, and we have certainly proved beyond a reasonable doubt that is exactly what happened. Mr. Corrales, known to Officer Jabro, was given a lawful order to move over onto the sidewalk, to which, as soon as they had that lawful order given, he became incredibly aggressive, incredibly defensive. You saw that video. It was played maybe 5 times at least where we heard the words, where he was insulting him and getting aggressive, flipping him off and getting closer with the camera, going into the officer's face. Officer Jabro testified that he believed that he, as it's pled, was in a reasonable apprehension of immediate bodily harm from the defendant in this case. Officer Jabro testified multiple times he saw him bringing back his arm with this blunt object in his hand to go hit him. I mean, that is absolutely proof beyond a reasonable doubt that Officer Jabro was in reasonable It was in a reasonable apprehension of immediate bodily harm from the defendant in this case. Moreover, with the obstruction, as soon as the defendant here is arrested, and is provided on the videos as well, Officer Jabro asks, do you have any identification, as is routine for cops to identify those who they are arresting or stopping? The defendant goes, no. It's in the left pocket. That's what the defendant says. When the officer does not find the ID in the left pocket, he asks again. At that point, the video will show you. He goes, no, this is a Terry stop. Is this a Terry stop? Not once does the defendant ever try and verbally identify himself, right? It's not like the defendant was like, oh, you're right, it's not in the pocket, but here's my name, here's my information, so I'm not obstructing your investigation, I'm not obstructing this arrest. So therefore, it is definitely proof beyond a reasonable doubt that there was obstruction on the defendant's part, as he refused to give any identifying information to the officer in the incident case. With that, I will submit.
Judge, the state has failed to meet their burden today at this bench trial to prove beyond a reasonable doubt that Cesar Corrales committed the crimes of assault, a misdemeanor, and obstructing a police officer. Certainly, as the way the complaint is pled, the specific allegation was closing distance in a hostile, threatening manner, taking an angled fighting stance while having a blunt instrument in his hand. And I would refer the court to the video of the actual incident, which is captured on Defense Exhibit B, which shows that at no point does Mr. Corrales actually move over with the camera to try to hit Officer Jabro, who testified today. At no point does he, and this is also confirmed by the testimony under cross, at no point does he make a threat to hurt him with his own hands, with his camera, to hurt somebody else, to hurt any property, to commit any other crime. What we see clearly in the video, obviously we're talking about somebody that used language that most people would find offensive, but that is not the crime that the state is prosecuting Mr. Corrales for. The crime specifically is assault on a protected person and obstructing. What I'd like to point out insofar as the statute and the reason why I had asked questions earlier as to the police report and the crimes that were originally the basis for the probable cause in this case. Assault has two theories. Assault is either a failed attempt at a battery, which is under subsection 1A, unlawfully attempting to use physical force against another person. There was zero evidence presented by the state today that Mr. Corrales attempted to commit a battery. When asked what a blading motion is, the witness got up and demonstrated simply moving the body in a certain direction. Not raising the arms, and not raising the legs, not trying to attack somebody. So the state has failed to prove assault as to that first theory. Now, the second theory is intentionally placing another person in reasonable apprehension of immediate bodily harm. As Your Honor asked him in terms of what he was trying to have happen that day, the officer in question with Mr. Corrales, there was testimony from the officer that at no point does he threaten bodily harm to him. At no point does he threaten bodily harm to somebody else. There is no action that Mr. Corrales took aside from the fact that he was recording in one hand and he was walking alongside the officer, and because he turned his body, the officer felt in fear. Feeling in fear is not enough for a conviction beyond a reasonable doubt as to the crime of assault. There needs to be reasonable apprehension of immediate bodily harm, and there was no testimony today to support that. As far as the state's burden as to count 2, obstructing, there is significant amount of case law to say that if there is no predicate offense as to an individual who is charged for obstructing, there can be no obstructing charge. So the way that it's pled, certainly the state has failed to meet a burden beyond a reasonable doubt. It says willfully and lawfully after due notice, refuse or neglect to make or furnish their identity. The testimony was that after being asked where his ID was, he complied and said where the ID was. The fact that the officer didn't find the ID has no bearing as to whether Mr. Corrales actually complied with the instructions to furnish his ID to the police. As it pertains to the arrest in this situation, I think what we have is proof of an unlawful arrest. And what the case law says under State v. Smithson, 54 Nevada 417, that is a still good law as it pertains to an unlawful arrest. It says the person thought to thus be unlawfully arrested may no doubt resist such an arrest with all proper and reasonable means. As to the obstructing, Nevada has even specified that where a person refuses to identify themselves, it is unlawful for them to be arrested for that crime alone. Even if an officer were conducting a Terry frisk, the case law says that a person is not obliged to answer the questions if there is no lawful basis as to the arrest. Defense is arguing here that there was no lawful basis for the arrest. It was the two people walking in the same direction. The officer testified he also was walking alongside him, and at the end of the day, what he constitutes as a blading motion is not sufficient proof beyond a reasonable doubt that Mr. Corrales put him in reasonable apprehension of immediate bodily harm. And once again, I would just point the court to both Exhibit A, which shows the interaction from the perspective of Mr. Corrales, and Exhibit B, which shows the incident from far away and shows clearly that two people are walking next to each other when suddenly the officer shoves him. And Judge, as far as the recording that happened in this case, obviously the officer testified that that did not bother him, but just if there's any doubt as to what Mr. Corrales was doing that night, he has a right to record, as the court knows, and in fact there are recent decisions from Judge Levitt as to obstructing and how a person cannot be convicted of obstructing for merely recording a police officer. And with that, I will rest. And we asked for you to find him not guilty on counts 1 and 2, and I rest.
On count 1, I find the defendant not guilty. On count 2, I consider the improper act by the officer that calls for him to ask for the identity. As far as I'm concerned, the officer, and he even admits that he wasn't threatened, and didn't threaten any other individuals, that in and of itself did not constitute probable cause for arrest. But however, that act did cause the officer to ask for his ID, which he refused. I think that act, which I say was improper, led to the action asking for the ID. And I find the defendant not guilty in that charge.